Hello, my name is Shibani Ghosh. I'm a lawyer specializing in environmental law. I practice in courts in cases dealing with the environmental issues. I'm also a researcher associated with the think tank in Delhi, the Center for Policy Research, where my work involves domestic environmental law and regulation. I have also worked with the Central Information Commission, which is the apex body under the Right to Information Act, and some of my research deals with the right to information. Today, the module that we are going to discuss is on procedural environmental rights. As you've perhaps read in other modules in this program on the Constitution and environmental law, Article 21 of the Constitution has been interpreted by our courts on several occasions to include the right to clean and healthy environment, right to pollution-free air and water, and hygienic environment. Now, all these are considered to be substantive rights. However, there is another set of very important rights which are necessary to effectively enjoy these substantive rights, and these are called procedural rights. These rights, although they're facilitative in nature, are no less important, and in fact, the Supreme Court has found them to be part of the fundamental rights guaranteed by the Constitution in Articles 19(1)(a) and 21, which we'll discuss briefly later on. Now, the two procedural environmental rights that we are going to discuss in today's class are the right to information relating to decisions and processes that affect the environment and people's lives and livelihoods, and the right to public participation and consultation in decision-making processes which impact the environment. I'm hoping by the end of this class, you will be able to understand the various facets of these rights, as well as some of the environmental laws and regulatory instruments which implement these two rights, the right to information and the right to public participation. Now, let us begin with the right to information. What does this right to information mean? It means the right to access information such as documents, reports, minutes of meetings, communications, maps, databases, etc., which may be relevant to or may have contributed to or which record decisions and decision-making processes of the government. For the purposes of this module, where we are discussing procedural environmental rights, so we're discussing in the context of environmental law and regulation, we are talking about decisions which impact or are likely to impact the environment and therefore the lives and livelihoods of people. An important aspect of the right to information is the right to be informed. If any person or community or its interests are likely to be affected, they have the right to be informed by the government or the policymaker about the decision that is being made that will affect their rights and interest. And this information has to come before the decision is made, so that the people or the community has the opportunity to protect its interests and rights before they are irreversibly affected. Now, although today we are discussing the right to information in the context of environmental decision making, the right to information is extremely important for the effective functioning of democracy as a whole. People must know and people should have access to information which is in the control of the government or government agencies. People must know about the decisions of the government, who will be affected by such a decision or a policy, and in what ways. What is the rationale that the government has adopted before coming to such a decision, what are the alternatives and the options that have been discussed, and who are the stakeholders who have either been consulted or the government proposes to consult. Now, all this information is information that people in a democracy must have the right to access. The right to information in India finds a source in the Constitution of India, in the Fundamental Rights section. Now, you must be reading about the fundamental rights in some other modules, but here we look at two fundamental rights in particular, the fundamental right under Article 19(1)(a) and the right under Article 21. 19(1)(a) guarantees all citizens the right to freedom of speech and expression. Right to under Article 21 says, no person shall be deprived of life or personal liberty except according to procedure established by law. As you can see, neither of these rights actually mention the right to information. However, the Supreme Court of India in several cases has come to the conclusion that these rights have to be liberally interpreted, because for these rights to be enjoyed effectively, every citizen or every person in India must have the right to information. So let us now look at some of the relevant excerpts of important judgments that the Supreme Court has given in cases not relating to the environment necessarily, to understand the rationale why the Supreme Court thinks that the right to information is really a fundamental right under the Constitution of India. To begin with, let's look at a 1975 judgment of the Supreme Court in the state of Uttar Pradesh versus Raj Narayan and others, and I will read out an excerpt. The people of this country have a right to know every public act, everything that is done in a public way by their public functionaries. They are entitled to know the particulars of every public transaction in all its bearing. The right to know, which is derived from the concept of freedom of speech, which is though not absolute, is a factor which should make one wary when secrecy is claimed for transaction which can, at any rate, have no repercussions on public security. To cover with veil of secrecy the common routine business is not in the interest of public. Such secrecy can seldom be legitimately desired. So the Supreme Court of India in this 1975 judgment is telling us that government agencies, government decisions should not be hidden behind a veil of secrecy, and that citizens of the country have a right to know what every public functionary is doing. In a second judgment in 1982 in S.P. Gupta versus President of India, the Supreme Court holds the concept of an open government is the direct emanation from the right to know, which seems to be implicit in the right of free speech and expression guaranteed under Article 19(1)(a). Therefore, disclosure of information in regard to functioning of government must be the rule, and secrecy and exception justified only where the strictest requirement of public interest so demands. The approach of the court must be to attenuate this area of secrecy as much as possible consistently with the requirement of public interest, bearing in mind all the time that disclosure also serves an important aspect of public interest. Yet again, we see the Supreme Court saying that the right to know comes from the right to speech and expression. If we want to be able to express ourselves freely and to form an opinion freely without any kind of encumbrances, we must have the right to access government information or the right to know. In two other cases, in 1988 and then followed by 2005, the Supreme Court says in Reliance Petrochemicals versus Proprietors of Indian Express newspapers, we must remember that the people at large have a right to know in order to be able to take part in a participatory development in the industrial life and democracy. Right to know is a basic right which citizens of a free country aspire in the broader horizon of the right to live in this age and in our land under Article 21. So we see the Supreme Court is now bringing on Article 21 and the right to life, from which it says also that the right to information finds its source. In a case in 2005, the Supreme Court says in Research Foundation for Science, Technology and Natural Resource Policy versus Union of India, the right to information and community participation for protection of environment and human health is also a right which flows from Article 21. This case, as we can see, is specifically to do with environment and human health, and the court says that the right to information and public participation actually finds a basis in Article 21, which is the right to life. The right to information has a basis in the Constitution and the fundamental rights, but it was given a statutory status in 2005 when the Parliament of India passed the Right to Information Act 2005. Under this act, every citizen of India has the right to seek information from public authorities. What is information? Information is, for instance, records, documents, memos, email communication, file notings, press releases, advices, circulars, orders, samples, models, data held in electronic form. All this is information under the Right to Information Act. Information relating to a private body may also be sought under the Right to Information Act. So it's not just information held by public authorities, but also those held by private bodies. However, this should be information that public authorities can access through law from the private bodies. Examples of information which are relevant for our purposes, i.e. in the context of environmental regulation, could be data on emissions, on air pollution, EIA reports, environmental impact assessment reports, minutes of meetings of expert committees, inspection reports, photographs, file notings recorded by the government officials on a file, or circulars and orders passed in relation to environmental regulations, like, for example, the CRZ notification or the EI notification of 2006. The RTI Act sets in motion a detailed mechanism to seek information. Public information officers and first appellate authorities have been appointed in public authorities across the country, and there is a time-bound manner in which information has to be provided once it is sought by an RTI applicant. If there is any delay in providing this information, or there is no legal justification for denying this information, a penalty can be imposed under this Act by information commissions at the central level as well as the state level on persons who are directly responsible for the delay in providing the information. In terms of the environmental laws, let's look at the two major pollution prevention laws that we have: the Water Prevention and Control of Pollution Act of 1974 and the Air Prevention and Control Act of 1981, popularly known as the Water Act and the Air Act. These two laws are extremely important with regard to pollution related issues in India, and they set up the state pollution control boards in every state and define the powers and function of these boards. One of the main functions of the State Pollution Control Board under these two acts is the function to grant consents to industrial plants to establish and to operate under various provisions. So, for example, under the Water Act, unless an industrial plant has obtained a consent from the State Pollution Control Board, it is not permitted to discharge any effluents in the water stream. So, first an industrial plant has to obtain a consent from the State Pollution Control Board, and this consent would include certain standards of discharge within it, and failure to maintain these standards could mean that the operation could be shut down or the industrial plant could be shut down. Now, a complaint may be filed by the State Pollution Control Board if any industry is violating the standards that have been set within the consent to establish or consent to operate that has been issued to it. Even a private citizen can file a complaint against an industry in case of such a violation. However, what is important is information about these consents has to be available in the public. Who has been granted these consents? What are the standards that have been set by the State Pollution Control Board, and the other particulars that have been included on the consent? Now, the Water Act and the Air Act both require that the information about these consents be recorded in a register, and these registers be made available to the public for inspection and at all reasonable hours, and anybody who is interested or is affected by violation of these standards can access the information in these registers. If these registers and the information with regard to consents is not made available to the public, action can be taken against the State Pollution Control Board. So, we see this is an example where information has to be made available in the context of environmental decision making to the public, so that people have the right to access these registers and also complain to appropriate authorities in case these registers are not maintained properly, and in case, of course, they find that the consents that have been issued and the particulars that have been included in the registers have not been complied with. Moving on to another example with regard to right to information in environmental decision making, or the procedural environmental right to information, let's look at the EI notification of 2006. Under the EI notification of 2006, all industrial activities and projects like mining, thermal power plants, hydropower plants, industries, building and construction, pipelines, all these kind of projects and infrastructure developments require an environmental clearance before they start any form of operation. Now, there are several stages in this process, and it's been discussed in great detail in a different module on environmental clearance under the EI notification. So, I'm not going into much detail here, but let's look at three aspects of this process which relates to right to information. The first aspect comes in the stage of scoping, where terms of reference are issued to the project proponent who has come to the ministry to obtain an environment clearance. These terms of reference basically form the basis for the environmental impact assessment studies that the project proponent has to undertake. Now, these TORs are issued by expert appraisal committees, and once these TORs, or the terms of reference, are issued, they have to be made public. They have to be made available on the website of the Ministry of Environment and Forest, or the state level concerned agency at the state level, so that people know what were the final terms of reference that have been issued to the project proponent. Why is this important? Because environmental impact assessment studies, which basically see what are the potential impacts on the environment of a project, of an industrial activity, these assessment studies are based on the terms of reference, the criteria laid down in these terms. So, people should know whether the impact assessment studies have been done completely, adequately, meeting all the terms or not. The second example of where right to information comes in the environment clearance process is the public consultation phase. Of course, we will be discussing public consultation as a procedural right in itself, but before the public consultation stage begins in the EI and the environmental clearance process, there is certain information such as the environment impact assessment report, the pre-feasibility report, Form 1, summary of the draft EI report, several such important documents that have to be made available 30 days in advance to every person or in every office, local offices near the project site. And even on the Pollution Control Board's website, the MOEFCC's website, all these places have to have this information available. The reason for this is that people must understand the nature of the proposed project, its likely impacts, and how their lives and livelihoods would be affected by this project. And what are the factors that the project proponent is taking into consideration. All this information has to be made available to people before they are able to participate in the public consultation stage. So, they have a right to access this information. If this information is denied to them, if these documents are not made available to them 30 days before a public hearing is held, they have a right to approach appropriate courts to demand this right and to say that the environmental clearance process has not been properly held. The final example of the EI notification and the right to information is actually once the environmental clearance is granted. There is a duty on the project proponent that once the clearance has been granted, it must advertise the entire clearance letter, including the conditions placed on it, on its website, as well as advertise it in 2 newspapers, one a regional newspaper and one an English language newspaper. It has to be also sent to the local offices such as that of the Gram Panchayat or the Zilla Parishad or the district administrative offices of the district collector. All these local offices which are in close proximity to the project site also have to be told about or informed about these clearances and have to display the clearance clearly for 30 days at least. It has to be also made available on the website of the Ministry of Environment and Forest or the state level Environmental Impact Assessment Authority. Now, the right to know or the right to be informed that the clearance has been granted, and more importantly, the details of the clearance have to be made available so that people are prepared for the future project work. And in case they want to challenge the grant of clearance, if they want to challenge the decision of the government to give the clearance to the project, then they must have time to approach the National Green Tribunal, which is a specialized court to hear these kind of grievances. They must also know the conditions that have been imposed on the project so that they can verify whether the project proponent is actually meeting these requirements. So, for example, if the project proponent has been is required by the clearance letter to ensure that a green belt of a width of 500 meters is built around its project site, if people know of this clearance condition, they can verify whether that has happened, and if it hasn't, they can report non-compliance. Now, we will move on to the next set of procedural environmental rights, which is the right to public participation and consultation. It is the right of the people to be consulted, to be engaged by the government before it takes a decision which affects them. It is not only fair because it affects them, but it is also necessary to seek their views so as to incorporate their views and ideas, and even in some cases expertise into the decision-making processes, because it's possible that there's some local level knowledge, indigenous knowledge, which is available to people in that project area or in the area in which the development is going to come up, which is not available even to great scientific and technical experts. Now let us again look at 3 environmental regulatory instruments where right to public participation and consultation has been included. First, we can look at the Environment Protection Rules of 1986, which have been issued under the Environment Protection Act of 1986. The Act gives the power to the central government to prohibit or to restrict the location of industries and carrying out of processes, keeping in mind the environmental impact of such industries or processes. In the process, the government has to issue a notification giving out the rationale for restricting the area or regulating the area, which are the industries which will be affected, which are the areas. All this information has to be put in a notification and put out for consultation for at least 120 days. During these 120 days, anyone can raise objections. The rationale behind this is all stakeholders, whether it's civil society groups, project affected persons, industries, anyone who might have a say in why the notification should be differently drafted, whether increasing the restriction, reducing the restriction, changing its scope. All these people must have their say. Therefore, this form of public consultation is encouraged under the Environment Protection Rules. However, there is an exception to that. If the central government says that there is certain public interest in not waiting for 120 days for the public consultation to be over, the government may rule out the requirement for public consultation. However, if it does so, it would have to give reasons in writing. A second example is the EI notification of 2006, which I mentioned in the context of the right to information, but I'll now discuss the public consultation process under the right to information, which is divided into 2 stages, which is a public hearing and the second is written responses. Now, public consultation is defined under the EI notification as the process by which the concerns of local affected persons and others who have a plausible stake in the environmental impacts of the project or activity are ascertained, with the view of taking into account all the material concerns in the project design as appropriate. Now, all projects in India have to undertake the public consultation before they are granted a clearance. However, certain projects that are exempted are projects such as building and construction, townships, expansion projects, that have been started for national security purposes. All these projects do not require public consultation. Now, as I said, there are 2 stages in this. Public hearing, which is attended by locally affected persons and is held at either the project site or in its close proximity. It is facilitated by the concerned State Pollution Control Board. And the proceedings of these public hearings are then sent to the concerned regulatory authority, whether it's the Ministry of Environment, Forest, Climate Change or the state level Environment Impact Assessment Authority. The second stage is written responses from people who may have any plausible stake or interest in the matter, who want to raise any queries or bring some information or data to the government's notice. Now, before the public hearing process begins, as we discussed, there's certain information that has to be made available to the people. This is done after the project proponent writes to the Pollution Control Board and says that we have this proposed project, here are the concerned documents, and please hold a public hearing. The State Pollution Control Board then makes an announcement deciding on the date, venue, time of the public hearing, and puts out a notice. Now, this notice and all the documents that have been submitted by the public project proponent have to be made available to people at least 30 days before the public hearing is actually held. And the reason for this is if people have to effectively participate in the decision-making process, they must have access to all this information. During the public hearing itself, which is, as I said, facilitated by the State Pollution Control Board, but it's supervised by the district collector or the district magistrate or the subdivisional magistrate, There is no quorum requirement. However, any person who is attending this process has to mark attendance. The project proponent is invited to explain and make a representation about the project, various aspects of the project, what are the measures that are being taken by the project, what are the pros and cons of the project. And after that, every person who is present in the hearing has to be given an opportunity to speak if he or she so wishes to, raise objections, ask queries and clarifications. After that, the panel of the public hearing, which as I said was headed by the district collector or the SDM, prepare the minutes of the meeting, which is then read out back to the audience to ensure that they have recorded or the minutes reflect exactly what happened in the during the meeting. These minutes that have been verified and a video recording that is undertaken by the State Pollution Control Board of the entire hearing is then sent to the Ministry of Environment and Forest or the state level expert appraisal, state level Environment Impact Assessment Authority. Now, after this public hearing, public consultation process is over, the project proponent may revise its report based on the concerns raised during the public consultation. It is required to do so. However, unfortunately, it has been seen many times that project proponents don't take the public consultation stage very seriously and do not make the required changes in the EI report before finally submitting it to the ministry. At the appraisal stage, the public hearing video as well as the minutes of the public hearing and any representations that may have been made are considered by the expert appraisal committee and are likely to influence the process of granting environmental clearance. Because during the public consultation, if there is certain information that is brought to the knowledge of the expert appraisal committee and the MOEF that was not brought by the project proponent or that is contradicted, it reflects in the final decision. Based on objection raised during the public hearing, expert appraisal committees are known to have rejected proposals before them, or at least to have required project proponents to undertake additional studies. Therefore, we see that during the EI process, we have the public consultation stage playing an extremely crucial role in the final decision of whether to grant the environmental clearance or not. We'll come to the last example of the public participation, the right to public participation, which is the Forest Rights Act of 2006. The long name of this act is the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act of 2006. Now, this act recognizes the rights of tribals and forest dwellers who primarily reside in the forests or who depend on the forests for their lives and livelihoods. These rights include the right to hold and live in forest land, the right to own and to access, use and dispose of minor forest produce, for example, tendu leaves, right of use or entitlement to fish and other products in water bodies, grazing rights, traditional seasonal resource access. So all these rights are recognized by the Forest Rights Act. These rights could be individually claimed or could be claimed by a community as a whole. The Forest Rights Act and the rules laid down under the Act give a detailed procedure for the settlement and recognition of these rights. Where does public participation come in here? The public participation comes in because Gram Sabhas, which as you know are village assemblies including all adults in a village, are designated as the authorities to initiate proceedings. So the Gram Sabha, which involves everyone in the village, they receive and hear claims for forest rights, prepare a list of claimants, give a reasonable opportunity to everyone who's concerned before finally making a decision on granting rights. Now, this is an important illustration of how public consultation plays a role in decision making with regard to natural resource, in this case forest rights. Very often you will see that the right to judicial remedies or the right to access justice is also considered to be a procedural right. I haven't gone into too much detail here because there's a separate module with regard to judicial remedies which discuss this, but just briefly to say that the procedural right to effective access to justice means that courts or tribunals or redressal mechanisms should be easily accessible to people, should not be very costly, anyone should be able to approach them, and even if they have limited means, even if they are poor, there should not be any bar in approaching the courts of law. Now, these courts could be of any form. It could be the Supreme Court, the High Court, the lower courts, or it could even be a special tribunal like the National Green Tribunal that I referred to earlier. Now, more details about the possible judicial remedies in environmental cases is available on the in the module titled Judicial Remedies, which you can refer to separately. Now, what have we learned today? Let me summarize our discussion for today. We started by discussing that there are a set of rights which are distinct from substantive rights, which are referred to as procedural environmental rights. These are rights which are extremely important to be able to effectively enjoy our substantive right to clean and healthy environment. I highlighted two rights, the right to information and the right to public participation and consultation. I then talked about the right to information in the context of the Right to Information Act 2005, in the context of the Water Act and the Air Act, where I talked about registers which have to be made available to people, as well as in the context of the EI notification 2006 and the documents and the information about the clearance that has to be made available to people. In the second set of rights, the right to public participation and consultation, I gave the example of the Environment Protection Rules, where draft notification has to be made available to people to be able to respond to and raise objections or express their opinion. I also talked about the public consultation under the EIA notification of 2006, and finally under the Forest Rights Act of 2006. At the end, I briefly mentioned that in some cases, the right to access justice or the effective access to justice is also considered to be a procedural environmental law. However, details of this right to access justice is available in a different module. Thank you very much. I hope you enjoyed this session and learned something out of it.